evening, welcome. This is Hot Edition. We're live from a news about this weekend. Also live on Kesme 107.1 in Tamale and beyond. We're live on W 93.5 in Wa and beyond. Also streaming live on Facebook at 3FM927, also on YouTube at 3FM927. Read out to you and to the rest of the world. This evening here on Hot Edition, Attorney General and Minister for Justice Dominic Ayine defends decision to discontinue criminal prosecution of Dr. Kwabena Duffuor and 7 others in the Unibank collapse saga, but the minority demands immediate reversal of the decision as it hints of its intentions to drag the Attorney General before the court of law. Stay with us. We've got details for you. Also, 8 suspects in National Service scandal seek plea bargain, offer to testify. That's according to the Auditor General. That's the Attorney General. We've got details for you here on Hot Edition on 3FM 92.7. Also, the Nayiri Palace rejects Nalerigu Curfew, says government disrespected traditional authority. Here on Hot Edition, we've got some details for you on that particular development as the Mamprugu Traditional Council is condemning that imposition of the curfew on Nalerigu and its surrounding communities, describing the decision as arbitrary, unjustified, and a direct affront to the authority of Nayiri. Where the National Peace Council has also called on the feuding factions to continue to subject themselves to the Otumfour-led mediation effort. This evening, stay with us. We've got details for you here on Hot Edition on 3FM 92.7. Also this evening, the Ashanti Regional Security Council disassociates itself from activities of a group that reportedly invaded the Forestry Commission offices in the region. Stay with us. We've got details for you here on Hot Edition on 3FM 92.7. We're also on Kesme 107.1 in Tamale and on W 93.5 and Wa and beyond. Just coming through from the Ministry of Lands and Natural Resources, government has cancelled the $1.2 billion bauxite deal. ICE Global Partnership, according to some sources, will speak to the CSOs in this extractive industry who have not been too happy about this particular bauxite deal and where the bauxite was going to be mined. Stay with us. We've got details of these plus the latest in business and sport over the next 1 hour here on Hot Edition. I am Alfred Ocansey. Let's get into a summary of the news now.
Thank you very much, Alfred. The Attorney General and Minister of Justice, Dr. Dominic Ayine, has defended the government's decision to discontinue the prosecution of Dr. Kwabena Duffuor and 7 others, saying more than 800 million Ghana cedis has already been recovered, with the remainder being pursued through a structured payment arrangement. In other stories, the minority has asked the Attorney General, Dr. Dominic Ayine, to immediately reverse his decision to discontinue the high-profile criminal case against Dr. Kwabena Duffuor and 7 others or face legal action. Attorney General and Minister for Justice Dr. Dominic Ayine has announced a sweeping reform to Ghana's legal education system that would abolish the current Ghana School of Law admission structure and replace it with a national bar examination. The proposed changes are part of a new legal education bill expected to be submitted to Cabinet in August. The reforms aimed to decentralize professional legal training and expand access to the bar for all qualified LLB graduates. Under the new model, students who obtain LLB degrees from accredited universities will undertake a 1-year bar practice program at their respective institutions. Upon completion, they will sit for a standardized national bar exam to qualify for legal practice. And just before we go, the Mamprugu Traditional Council has strongly condemned the government's imposition of a curfew on Nalerigu and its surrounding areas, describing the move as arbitrary, unjustified, and a direct affront to the authority of the Nayiri. In the statement, the Nayiri Palace expressed its displeasure over the curfew imposed from 2 p.m. to 6 a.m. daily, effective July 27, 2025, stating that the decision was made without prior consultation, despite Nalerigu's being calm and devoid of any ongoing conflicts. You've got this on 3news.com. Over to you, Alfred.
Let's stay a bit further on these matters developing here on Hot Edition on 3FM 92.7, also on Kesme 107.1 in Tamale. We're live on W 93.5 in Wa and beyond. And the Attorney General and Minister for Justice, Dr. Dominic Ayine, has defended the government's decision to drop the criminal case against the former Finance Minister, Dr. Kwabena Duffuor, and 7 others persons being tried for their role in the collapse of now defunct Unibank. Now, speaking during the government accountability series at the Jubilee House earlier today, Dominic Ayine explained that the withdrawal was based on a structured 2 billion Ghana cedis repayment agreement proposed by the accused, aimed at settling their revised obligations totaling 3.3 billion Ghana cedis. He said the legal complexities and the renewed focus on asset recovery informed the decision to enter a nolle prosequi. The justification comes amid scathing criticism of his decision to drop all charges against the accused persons without recovering a substantial sum of the funds lost in the collapse of the banks. This is what Dr. Dominic Ayine said in his defense of that decision to enter nolle prosequi earlier today.
The real economic value to the state lies in a non-conviction based asset recovery approach. The terms of the settlement are structured to ensure that the Attorney General, the Bank of Ghana, the Minister of Finance exercise oversight over the recovery of the negotiated amounts. Progress under the agreement will be subject to quarterly reviews to ensure that the accused persons fulfill their obligations as agreed. Ladies and gentlemen of the media and my fellow countrymen and women, it is important to correct certain misunderstandings or distortions, deliberate in some cases, that our team picked from the media space regarding this matter. Since my press release, it has been said that by setting a minimum threshold of 60% for the recovery of assets as a condition for filing a nolle prosequi or terminating the banking sector cases, I have cut a deal which permits persons who have stolen or looted public funds to walk away with 40% of the loot. At least that is the narrative, by some sections of, the Ghanaian populace, particularly from our opponents in the MPP who were responsible for all this mess. Indeed, one writer on Facebook compared my decision to the situation where someone has stolen 6 goods and is being told by the prosecutor to return 4 goods and keep the 2. But my fellow countrymen and women, now this may seem like a joke, but it's a very serious expression of the sense of justice of our community. And it is something that I have used, to, get people who have come to me for plea deals to get them to think about the community's sense of justice. So, it is not lost on me, and I wasn't surprised when I read this on Facebook. But the goat thief analogy, intriguing though it may be, is an oversimplification of the matter. This is why. First, Dr. Kwabena Duffuor and the other persons standing trial were not charged with stealing or looting of public funds. They were charged with causing financial loss to the state, fraudulent breach of trust, falsification of accounts, as I've pointed out earlier, dishonestly receiving, and money laundering. But the facts and the evidence supporting these charges never allege that those standing trial personally benefited from the banking transactions that gave rise to these charges. Now, it's important to make clear that when someone is charged with, for instance, causing financial loss to the state, all right, it does not imply from a criminal liability point of view that they took the resources that have been lost. In other words, what we seek to do when we charge someone with causing financial loss to the state is to prove that they either intentionally or recklessly or negligently cause the state to lose resources or to lose funds.
That's Dr. Dominic Ayine, the Attorney General and Minister for Justice there. But let's stay a bit further on this issue. Adam Senanu is the co-chair of the Citizens Movement Against Corruption. Senanu, thank you so much for joining us. This is a position that, in fact, you had held prior to today, asking for some more detail on what led to the 60-40 arrangement. That is the detail that Dr. Dominic Ayine gives today, that these persons, that's Dr. Kwabena Duffuor and the 7 others, were not charged with stealing. And even with the causing financial loss to the state, it does not necessarily mean in criminal jurisprudence that they personally took the money that was lost. It could be as a result of negligence and some inaction on the part of the accused persons. Does this tick the box for you with the explanation that you were asking for as to what led to the 60-40 arrangement with the Dr. Kwabena Duffuor before the Nalerigu was filed?
Well, although the transparency by the Attorney General is very much welcome, and he was at pains to try and explain the circumstances, yet it does not actually explain why the minimum threshold was 60% and not 70, 80, or 90. It also does not explain why this plea bargain situation starts with this particular case. Because part of the question in my mind is, don't they have several other similar cases? Why is the first one that deals with somebody who has had some party affiliation and some affiliation with the Attorney General himself? Because the optics don't look good, even though substantively the issue is not of the optics as much as the precedent we are setting. How does it help us continue to retrieve money from other cases? So, yes, it's been helpful getting some more detail, but the substantive issue of why 60%? Because you see, you would not have the person was not guilty or doesn't believe that they've done anything wrong altogether. They've not breached any law. There's no point in even getting into a negotiation. So I'm just wondering, why 60%? If they really caused financial loss, what was the hindrance to getting all or 90%? And having taken this position in this instance, and we are not clear how the team arrived at the 60%, how will they manage subsequent cases if the people started arguing that, well, you said the precedent and it's just equitable to make sure all of us are, if anything at all, we are looking at 60%. Apart from the fact that I'm still wondering whether that 60% is now in the coffers of government. I'm not sure I heard as I listened that was affirmed. So those are the issues. Yes, some additional information, but we are not entirely clear that this has been fully dealt with.
I see, but then on that question about why 60 and not 70, 80, 90, he says that, and this was his quote, that it will be unrealistic for anyone to suggest that 100% can be recovered. And he explained, giving details why that position in his view was quite problematic, because this is a case that the complexities involved in the case wouldn't have then giving that particular expectation any basis of merit that 100% could be recovered. Mezano.
I think that if the AG had given a sense of the complexities that make this impossible, that would have been helpful. I mean, it's one thing if you because, we are all just trying to analyze the facts. So if you don't provide us with the facts that make this complicated, we are wondering, why do we think that 80% is not possible in this instance? What are those other complicated factors or complicating factors that make it difficult to say, look, the money was invested in this, in that asset, and so on and so on and so forth. We'll retrieve this, and then the rest you can pay by installment over the next 2-3 years. And because this is what happened, there's an interest you pay. I mean, the reason is, why are we just stopping with the 60%? What are the complicating factors that don't allow other, models to be used, other payments to be made? There's no clarity on that. So yes, we can well believe our AG when he says it's complicated, but it is important that he gives us some of the facts so that then, with all the optics of this being somebody who is affiliated with him in the past, affiliated with the party, we don't seem to be creating, a space or an avenue to make it easy for some people. That's the worry. How would they manage the subsequent cases in the context of this case? It hasn't been addressed. And why 60% in this instance? If there are complications, I think it is useful for those specific factors that make this complicated to be provided to the public. Then we can judge that, yes, truly, it's impossible in this instance to get 80% rather than 60%.
I see, and that point you make about, the spirit of transparency. I mean, the Attorney General, has set a particular precedence in motion right now in going out to give reason or explanation for entering nolle prosequa or discontinuing cases, which was not the case hitherto. And the law doesn't even bind him to give reasons. He's decided to do so in the spirit of good governance. How is this working for the Attorney General? Is it working for his good so far, or opening himself up for more scrutiny, which may eventually tend to hurt the entire objective of him trying to put out some level of transparency?
I think this is one of the instances where there's both the positive and then there's also the potential negative. The positive is that, yes, it's a good trend for an AG and indeed for all our anti-graft agencies to be more open and transparent. It is why, as I keep repeating in Act 959, we OSP every 6 months, maximum. So we actually expect much more frequency in reporting to the people and carrying us along, so that if there are any facts or other additional information, those who are aware can whistleblow, etc. So it's a good thing he's doing, and it's something to be commended and highly commended at that. Now, that's on the transparency side. On the accountability side, sometimes it's just the rationale and the logic of it. We are wondering, so the next case, how will you handle this? What arguments are you going to make when the person says, well, I just have about 60%, I don't have enough to do 70%. How do you argue that out? How do you prevent others from taking advantage of this? And doesn't it set a tone where somebody can say, well, I know the rule now is 60%, so let me steal as much as I can, then get into a plea bargain and use this as an example and say, therefore, I'll keep the 40%. So the more I steal, the more I default the state, the better for me, because 40% of whatever amount is what I'll keep. I mean, these are the risks we are exposing ourselves to. And I think that we need to apply ourselves to it as we take these actions and be cautious, so that we are clear in our minds how will we manage similar cases going forward. Otherwise, it's a very risky road we appear to be taking. And without additional information, it's difficult to fully appreciate how the legal team expects to handle these cases.
And before I let you go, and this is another matter that I know you are very much interested in when it comes to the Operation Recover or Loot and what the Attorney General is doing. What we're hearing now is that there's going to be, on the matter of illegal mining, he says that this won't to make case as well. He gave an update on that. He says there's going to be more special courts coming to tackle galamsey. I wanted to take a listen to it, because that's a special area of interest for you as well as citizens' movements against corruption.
Questions.
We'll hear from
in some of the sectors. For instance, if you ask what will happen to CBG, that is better answered by the Minister of Finance and the Governor of the Bank of Ghana. Now, with respect to Abile Kumanov, the arrests have been effected, and you know that you don't go straight, to court. You need to conduct an investigation, prepare a docket, and then you proceed to charge law schools. Now, I don't know what you meant by being able to run all these programs and so on. So it is not a duty. If government wants to subsidize them, that is a different matter, legal education. And that is very, very important. And that promise is that we are going to reform legal education in such a way that access will be expanded, to the effect that we are going to literally abolish the Ghana School of Law system. All right. Basically, what we are going to do is that you will have 3 years of legal education to obtain your degree. That is the LLB. After obtaining the degree, the LLB degree, you now do what we call either the clinical legal program or the bar practice course in the university where you got your LLB for another academic year, and then you pass you become a chartered accountant. That is what is going to happen in order to expand legal education in the country. So the bill, as I speak, in fact, yesterday that I sent it to him. Then there is the question of the assigning of the properties. Okay, that was something that the shareholders, kept saying. You see, the whole case centered around these related parties, activities, okay, transactions, okay, where Holder Holdings, Uni Securities, of course, in the press release, you remember the 0.3 billion, which was given to, which was given to Uni Securities, which is a SEC-regulated entity, which is being pursued. Okay, so the whole idea, that is why the misconception being spread by certain elements, certain citizens, to the effect that Duffuor and his family were basically looting, resources from the bank, is misplaced. Okay, these were all related entity transactions. Okay, and I will encourage all of you, you should probably read the Beige Capital Court of Appeal decision, because the scenarios are the same.
Before we get into the Galamsey matter, and kindly pardon me, what we just heard the Attorney General talk about was this whole Duffuor case and the misconception out there about how this whole case played out. He says there was no matter of misappropriation of funds, but rather some internal arrangements or some third-party dealings that still had to do with the Duffuor other related party lending. Now, does that bring the matters into context, especially with the minorities' claim that to the extent that Dr. Dominic Ayine has been associated with Dr. Kwabena Duffuor in his past life as a lawyer for Unibank, there is a potential conflict of interest?
Well, it does. And I'm not sure he recognized himself that by speaking on this issue and positioning himself to speak on behalf of the Duffuors and what happened or what didn't happen, he appeared to stray out of what he should have been fully responsible for. It's not one of the things we would be expecting him to have to be the one explaining to the public. And that's part of the reason why potentially maybe this is one of those cases where he should have recused himself, and maybe he had the Deputy Attorney General or somebody else much more neutral or less connected with the facts handling it. So yes, as you know, constitutionally we say that public officers should refrain from putting themselves in positions of potential conflict of interest, not just substantive but potential conflict of interest. So there is some merit when the minority begins to raise that angle as well. And I pray that he will be conscious as we proceed to avoid such situations.
See, but then there is the argument as well one will put up is that, in his professional capacity now, do you see this actually happening in practicality, as it were, you haven't worked, in part and cross your path or cross his path, or he crossing your path at any point in time? Any merit of this actually becoming real? Because conflict of interest could be perceived, could be real or apparent, is it not?
But you just provided an example. Is it up to our AG to be the one speaking to what happened in Unibank or what did not happen, and whether it's a perception or not a perception? On what basis would our AG at that time be speaking on this? That's the question. Is he lawyer for Unibank? Is he lawyer for the Duffuors? Do you get the point? In this particular position, he's supposed to be lawyer speaking on behalf of the state. So that's how you can easily meander into a situation of conflict of interest and not even recognize it. So clearly, he just needs to be cautious about these issues before you end up speaking and apparently it's as if you have a mandate to speak on behalf, or, is that what you say is a final conclusion on the matter in terms of the evidence in relation to a particular issue, which others are contesting, and for which reason a case was brought up. So there is, and when we say potential conflict of interest, it includes situations like this where the optics, where others looking at the situation can draw a conclusion. It may not be even evidence-based, but potentially that this man was connected. He was a defense attorney for this particular group, and now he has this position, but he still seems to be speaking on behalf of this person. So that potential conflict of interest is what the Constitution even says you should avoid.
And maybe quickly before I let you go, on this point he made about this more specialized course to be established on matters relating to illegal mining, how would that advance the cause of the fight against galamsey?
Well, it will be very useful. In fact, my view is that we need specialized courts for everything dealing with anti-corruption and good governance, because the swiftness with which we arrive at conclusions on persons who have attempted to, defraud the state, take properties, and do things that undermine the state, it serves as a stronger deterrent. And we need that. I mean, other African jurisdictions like Kenya have as many as 12 specialized courts dealing with issues of anti-corruption and good governance, and they have a target of within 6 months trying to dispense of these cases. In that context, public officers, persons who are so minded know that, look, there's a system where I can easily be picked up, jailed and sanctioned, and so they'll be less inclined to getting themselves involved in such acts. So I think it's a good thing if it can be done, but it should not just be about galamsey. My view is everything to do with anti-corruption, good governance. Let's make sure we are establishing specialized courts with the kind of training that builds capacity to deal with this matter.
And I do appreciate your time as always. Thank you so much.
Thank you, too.
Senator is a co-chair of the Citizens Movement Against Corruption. But let's stay on this matter because the minority in Parliament addressed a press conference not too long ago demanding more from the Attorney General and threatening to go to the court of law. What exactly is the issue?
They are accusing the Attorney General of conflicts of interest in the Kwabena Duffuor criminal case, asking the AG to explain why he filed a nolle prosequi to free him. The caucus says the Attorney General has been pursuing his own agenda rather than following the theories of prosecution and punishment. Addressing the media in Parliament, the ranking member on the Legal Affairs Committee, Kwabena Duffuor, tasked the Legal Counsel to investigate the AG's action, further threatening to challenge him in court if his decision is not reversed immediately.
Why was the accused person not convicted, even when he agreed to pay 60% in line with plea bargain agreement under Section 35 or under the plea bargaining agreement or under Section 35 of the Caucus Act? For plea bargain to be accepted by the court, there are a lot of options opened to the parties, including conviction. However, any such process must be supervised by the court. In the learned Attorney General's nolle prosequi, he just enters. Nobody would have thought that we would ask him questions. But because he chooses to say that he wants to be transparent, we want him to be more transparent and answer the questions that we are asking him. So how the Attorney General allow the accused person to walk free without a conviction and without supervision of the process by the court? That definitely cannot be under a plea bargain agreement, as he had himself said. And if it is not a plea bargain agreement, and it also doesn't come under Section 35 of the Caucus Act, where did he get the 60% and how much has he collected? Today he tells us that he's going to make arrangements for the monies that have been collected, about 800,000 to be paid into government coffers. The learned Attorney General has obviously forgotten the theories of prosecution and punishment. In fact, if he had thought of it, he would have appreciated that deterrence is one of the theories that we take into consideration in punishing people. Ladies and gentlemen, as we conclude, we would like to take this opportunity to call on all voices of conscience in our society, especially lawyers, judges, civil society, clergy, traditional leaders, and you, the press, to sit down and watch, and not to sit down and watch on unconcerned, whilst the Attorney General, trusted with the office responsible to uphold the rule of law, on the contrary, pursue rather a destructive agenda to the detriment of the good people of Ghana. We therefore call upon any interested party, the Parliament of Ghana, particularly a Select Committee on Constitutional and Legal Affairs, to summon the Attorney General to answer these questions publicly. The Legal Council and Bar Association to investigate potential breaches of legal ethics and professional conduct. All patriotic Ghanaians to stand up against what appears to be the erosion of justice and the dangerous politicization of the prosecutorial process. Finally, may this press conference also serve as a formal notice to the Attorney General, Mr. Dominic Ayine, Dr. Dominic Ayine, that if his decision is not reversed within a reasonable time, the minority will consider its options of proceeding to court to challenge its decision in its entirety.
As a minority there. Also, the Attorney General, Dr. Dominic Ayine, gave updates on the Skytrain scandal investigations and the prosecution, and then also the National Service scandal, which he did detail that 8 suspects have sought plea deal in the National Service case as the Attorney General awaits more evidence from the Bank of Ghana, the Ministry of Finance, and the Controller Accountant General's Department. Take a listen to him.
This is Kwabena Duffuor and 3 others, and that of the Republic versus Solomon Asamoah and another. That is the Skytrain case. In the Kwabena Duffuor case, we are calling only 3 prosecution witnesses. Our first witness has concluded his testimony. But for the 3rd accused person's sudden withdrawal in open court of a lawyer's service, our first witness would have been discharged to give way to the 2nd prosecution witness to start testifying. We expect our 2nd witness to start testifying before the beginning of the legal vacation on July 31st, 2025. In the Skytrain trial, we have concluded the case management conference. It is important to add that, but for the change of solicitors and the multiple medical excuses of the 2nd accused person, that is Prof. Ameyaw Ekumfi, and recently of the lawyer for the 1st accused person, we would have called 2 of the 6 witnesses by now. That notwithstanding, the trial in the Skytrain case is expected to start before the beginning of the legal vacation. The National Service Authority scandal case was due to be filed last week, as promised, when we stumbled upon evidence of malfeasance involving an account at the Bank of Ghana to which had been transferred an amount of 189 million Ghana cedis. Out of this amount, 80 million Ghana cedis cannot be traced. But we found 2 checks bearing the name and account details of the former Director General, Mr. Osei Asibe, which had been used to withdraw funds totaling a little under 2 million Ghana cedis from the said account. We have therefore halted the filing of charges so as to await the receipt of the evidence from the relevant state agencies, including the Bank of Ghana, Ministry of Finance, and the Controller and Accountant General's Department. In fact, as I speak, the Bank of Ghana signaled to me that this morning they are going to deliver the entire, bank statement, for my attention. I am, however, thank you. Sorry. I am, however, happy to announce that at least 8 suspects in this investigation have approached my office for plea negotiations, including 3 former officers of the National Service Authority. Some officials have offered to testify against their colleagues, and some vendors and service providers are willing to come clean and testify as prosecution witnesses. When you build your docket well, this is the result that you get. 8, people are willing to testify. Persons, they are not coming to say hearsay. They are not coming to give hearsay evidence. People who were involved, okay? And we are, in negotiations with them and their lawyers. As a precondition, I tell them, you bring back the money that we have calculated that you took, you serve as a prosecution witness. That is the approach that we are using. Now, I'm sure the MPP will be very happy for me to insist that 100% be returned to the Attorney General before any deal can be, cut. Now, a report on the docket for the oral cases, including the mathematical sets, the All Africa Games, and the drip scandals are being prepared by the National Investigation Bureau for my attention. I expect to receive that investigative report in a few weeks for work to begin on filing charges in court. The Economic and Organized Crime Office has completed investigations in respect of Wontumi, Chairman Wontumi, and the former National Buffer Stock Company CEO, Mr. Abdul Wahab Hanan, and their accomplices. The results of both investigations will be announced very soon. The police CID have also completed a docket on the Akunta mining case and submitted same to my office. We have prepared charges and sent them back to the police CID for the suspects to be formally charged before their arraignment in court in the coming days. Ladies and gentlemen of the media, my fellow countrymen and women, in conclusion, I wish to remind you of the fact that when I announced the Kwabena Adu Boahene investigation, I was blunt in stating the fact that I am open to engaging in plea bargaining with those who have been investigated and found to have looted or stolen state resources. I minced no words about my intentions and will therefore not shut the door to any accused person willing to enter into negotiations with my office for purposes of reaching a plea agreement. My approach is in consonance with the central plank of the oral, which is to recover the loot, which is to recover all the loot. But of course, you use oral, all advisedly, because as I have pointed out clearly, it is not in all cases that it is possible to recover all the loot.
That's the Attorney General and Minister for Justice, Dr. Dominic Ayine, there. So live here on Hot Edition on 3FM 92.7. We're also on Kesmi 107.1 in Tamale and beyond, and also on W 93.5 in Wa and beyond. Let's go to the northern part of the country, specifically the troubled situation in Boko, and there's an update there. What do we know?
Yes, the Mamprugu Traditional Council has strongly condemned the government's imposition of a curfew on Nalerigu and surrounding communities, describing the decision as arbitrary, unjustified, and a direct affront to the authority of the Nayiri. In a statement issued today, the Nayiri Palace expressed disappointment over the curfew, which runs daily from 2 p.m. to 6 a.m. effective July 27, 2025, noting that it was enforced without any prior consultation, despite the area remaining calm and free from conflicts. The curfew comes in the wake of the killing of 2 students at Nalerigu Senior High School on Saturday, July 26, by unidentified gunmen. While investigations are ongoing, some locals believe the incident may be linked to the long-standing Boko conflict. However, the council insists that Nalerigu should not be grouped with the areas experiencing unrest, stressing that the community has remained peaceful. It also dismissed the government's explanation that the curfew was necessary to evacuate students, calling the reasoning unfortunate and unconvincing. The council warned that such reactive measures undermine peace building efforts and erode trust. They are, however, demanding these three things: that one, the immediate lifting of the curfew on Nalerigu and its environs; two, a thorough and transparent investigations into the students' murder with justice served; and three, an unqualified apology to the Nayiri and the people of Mamprugu for sidelining traditional authority. Alfred, meanwhile, the National Peace Council has condemned the recent spate of killings in Boku, Nalerigu and Asawase, describing them as barbaric, cruel, a gross violation of human rights, and a tragic setback to peace-building efforts. In a strongly worded statement, the council extended condolences to the bereaved families and urged security agencies to speed up investigations and ensure justice is served. It also expressed serious concern over the potential link between these incidents and the long-standing conflicts in Boku, warning of the growing insecurity in the region, especially in light of violent extremist threats from neighboring countries. The council called on all feuding parties to submit their grievances to the Otumfour Mediation Committee and for the revival of the Inter-Ethnic Peace Committee as part of efforts to resolve the crisis. It also emphasized the need for tolerance, mutual respect, and dialogue, and urged the media to exercise restraints in their coverage and commentary. It concluded by commending the government's swift response so far and called for decisive state action to restore peace and security in the affected areas.
Let's stay a bit further on this matter, and as quite troubling a development as it is. Right now, I've been joined on the telephone by Kwesi Boahene, the Senior Public Relations Officer for the National Peace Council. Mr. Kwesi Boahene, good evening. Thank you for joining us.
Yeah, good evening.
Now,
to you and your listeners.
I know you've been doing quite some work in this particular area, and now we're seeing this recent developments of violence that has led to an unfortunate loss of life. Now, this is coming at a time when there's an Otumfour-led mediation talks ongoing. I mean, what should be the immediate response to this development in the Boku enclave?
Our immediate response is we are condemning the killings. We've engaged the parties over the years, and we've made our point clearly that violence is not going to help anyone. Peace is what we all need to work towards. So that is our position as Peace Council, and we were engaging them on the inter-ethnic group committee. That was dialoguing over the while before it's called on a way. So we are just appealing to them to come back to the dialogue. We believe we can still talk things out and ensure peace returns there, side by side with what the Otumfour Mediation Committee is also doing. So we are just appealing to them to stop that, to stop the violence, to come to the negotiation table so that we keep talking and ensure that peace returns to Boku and its enclave.
See, now, beyond the appeal, there's also been that issue of lack of trust. And we see this dotted around the entire process, is it not? What should be done to address that element of suspicion and lack of trust on both sides?
Well, it's all to do with the posturing that we portray there. We have remained neutral. We are communicating the fact that peace is our utmost interest, and that is what we ought to all work towards. Then again, I think it's the commentary that we are having from others and the actions of others that is actually fueling these things. So we are just appealing that all, like we said in our statement, all media houses, individuals with interest, or those making comments that are exacerbating the situation, so stop. So that we give peace a chance by allowing the feuding parties to come to the table and continue the talks.
I do appreciate you, Mr. Kwati. Thank you so much for joining us on this matter. Kwesi, you're in Chibuating, a senior public relations manager at the National Peace Council. And from that appeal perspective, we go to the security response to this. And this is why I bring in Dr. Victor Doke. He is a security expert. Joining us with his thoughts on this particular matter, lecturer at the Kwabena International Peacekeeping Training Sector. Dr. Doke, appreciate you. Thank you for joining us. I mean, one would have thought until now that the Otumfour-led mediation talk was progressing steadily until we got this development. I mean, looking at how things are playing out right now and the loss of life and the response that the Traditional Council has given to the government statement imposing a curfew. What's your own reading of the evolution of this recent development in Boko?
Thank you very much, Alfred. Am I audible enough?
Yes, you are.
Okay. So my readings or interpretations with regards to all that you've spoken about. One, the Otumfour-led committee is progressing from what I gather. Now, the two sides, with regards to the Kusafi and Mamprugu, have stated their interests, their needs, and their wants. You would definitely be sure that as much as they're taking entrenched positions, there have been propositions or proposals made with regards to what either of them wants, okay? The scheme, that's it, recognition, respect, that's the main issue now. Aside that alone will fuse into any other minor issues that is outstanding in Boko and its enclave, i.e. issues about farmlands, i.e. issues regarding justice and how families can obtain justice, perpetrators brought to book and whatnot. With the curfew, it only means that the security agencies led by the defense and then Interior have picked up intelligence about either issues regarding some criminal elements, those enclaves who are perpetrating these acts, these violent acts on innocent people. And that is why the enforcement aspect has come to play. All along, for me, my interpretation is that we have been enforcing the peace. We have been enforcing curfews all along. So it is not now that we are enforcing anything. It has been there since. What will go wrong is when one side takes it upon themselves, or the youth representing one side now do not come to terms or agree with the outcome of the Otumfour-led mediation process. And that is where our concentration should be as security agencies, as stakeholders, especially government representatives, National Peace Council and CSOs, who are those who are going to be assistant with regards to implementing recommendations, bringing the feuding parties together, CSOs leading the course with regards to peace building approaches and mechanisms. So all this come to play. There should be a very comprehensive roadmap and mechanism so that immediately the mediation is over, every step that will be taken should be abided or should be respected by the two sides. And that is what will bring some finality to these skirmishes or violent acts we are facing.
A very comprehensive detail there and analysis. Thank you. Thank you so much, Dr. Victor Doke, for joining us on this.
Thank you very much.
He's a security expert and a lecturer at the Kwabena International Peacekeeping Training Center. Let's still stay on matters of some disturbances, this time in the Ashanti region.
Yes, there was confusion in parts of the Ashanti region this morning after individuals claiming to be operatives of national security forcibly shut down Forestry Commission offices in Kawie, Bekwai, and Akomadan staff were ordered out and access to the facilities was blocked without explanation. The abrupt closures disrupted official work and left both workers and members of the public seeking services stranded. Eyewitnesses say the group arrived in branded vehicles and presented no formal documentation before locking the gates. But in a sharp twist, the Ashanti Regional National Security Coordinator has dissociated his office from the operation. He described the individuals involved as imposters and warned that steps are being taken to arrest them for impersonating state officials. The motive behind the unauthorized takeover remains unclear, but the incident has sparked concerns over security and rising acts of vigilantism in the area.
National security staffs have not been sent anywhere. And those who are parading themselves as national security staff, and I'm not happy at all. And it's bringing a whole lot of issues because we don't involve ourselves in such issues. These people are party foot soldiers who have taken those places hostage. But due to our intervention, we have told them to leave the place. And whatever concerns that they have, they should submit it to the party or to the regional minister. We are talking about Otumfour North, in Kawie, and Bekwai. That's the report that I've had so far. And we have sent legitimate national security staff to go remove them from there and ensure that those offices are open for forestry staff who are to engage in their work. We have identified some of those people who are party people, and we are going to let the police pick them up, or we will pick them up and hand them over to the police ourselves. It is illegal to fight illegality with illegality. If you have a complaint about an institution, the best to do is to forward your petition or report to the regional minister or the party chairman to see how the system can be used to address it. But it is wrong for them to think that they can just besiege any institution in the name of national security or in the name of the party and hold up those institutions hostage.
Well, that was the Ashanti Regional National Security Coordinator who was speaking at the back of a confusion in the part of the Ashanti region where the Forestry Commission offices in Kawie, Bekwai, and Akomadan offices were shut down. Well, we'll be back with the business news. Bismasuku Ewusa is standing by.
Ghana. It's a new year and Bill's Microcredit is here to support your dreams. If you're not working but want to start a business, don't let money stop you. With just your Ghana card, you can get a loan to turn your ideas into reality. Already running a business? Need more capital? Or are you a salary worker looking for extra funds? Bill's offers fast and easy loans with no collateral, no deposit, and no SUSI savings required. Wherever you are, whatever you need,
That's it for Hot Edition here on 3FM 92.7. My name is Christabel. Success Trevor. I've been doing this with Alfred Ocansey. DJ faculty is standing by.